all rise. The Court of Appeals Division 1 is now in session.
Thank you all. Please be seated. This is a time set for oral argument in our case number CASA 240089, State of Arizona versus Superior Court, the Honorable Caston LaMare, real party in interest, Joel McLean Carson. Each side is given 20 minutes for oral argument. If petitioner or appellant, wishes to reserve a portion of that time for rebuttal, you're free to do so, but you need to keep track of your own time at the podium clock. Out of respect for counsel and to avoid any embarrassment, let me ask everyone in attendance to make sure your cell phones are off so our proceedings aren't being interrupted. We've read the briefs. The record in this case is a little different than a typical case, so please keep that in mind. If there are gaps, fair enough, but let us know. We have some questions for you, but we'd encourage you to keep that in mind in your presentations today. Our proceedings are being recorded. They'll be posted to YouTube in due course, so please, as you begin your argument, tell us your name and the party that you represent. With that, Ms. Davis, you may proceed.
Thank you. Good afternoon. May it please the Court, Christine Davis with the Maricopa County Attorney's Office on behalf of Petitioner State. As this Court is aware, and Judge Thurman, you've already alluded to, the criminal case against Joel Carson is very layered. It has a lot of history, perhaps we might say some baggage, but I would submit to this Court that the ruling that the state has special action, the very specific ruling coming out of the trial court in this special action, isn't especially complex. When a different panel of this court stayed its upcoming dismissal of the criminal case so that the state could pursue its options under 4517, there was no immediate challenge to that by Mr. Carson. It's not necessarily dispositive, but something that I did want to point out, because at every stage where there isn't a challenge, that limits the record before this court. I would also say that when the state accepted that panel's guidance and filed the petition for a dangerous trial in the trial court, again, there was no objection from Mr. Carson, let alone the development of any objections that have since been developed here through the petition and the response in the supplemental briefing. The trial court, as this court knows, denied the state's request based exclusively on its determination that it lacked authority because the finding of not competent and not restorable had been filed in another case number and attached to that case number instead of to Mr. Carson and to the charge that he murdered Efren Hernandez. I submit to the court that that was clear error under Johnson. And in fact, Mr. Carson agrees. In the supplemental briefing, he agrees that the state has the right to rely on that finding. And so, although I recognize the court's questions through the supplemental briefing, and I'm happy to address those further today, elaborate, answer more questions, I would suggest that that's really the only issue this court has to decide if accepting jurisdiction. And I would submit that the state should be able to return to the trial court and address through evidence and argument some of the additional issues that have been raised through the supplemental briefing, and should have the opportunity to make a good record for this court to possibly ultimately be able to resolve some of those questions. I did want to specifically address a couple of points that were raised in Carson's supplemental brief that I think may be of interest to this court. And the first is the existing mental health case. That case, the state submits, actually demonstrates why the civil commitment process is inadequate and why the legislature passed 4517A4. And what I mean by that is you have really this case, the facts, the underlying facts, which I won't heavily go into, I know the court's familiar, is sort of the poster child case for why the legislature passed 4517A4, because the average length of stay when a defendant is remanded through the mental health process, the average length of stay at Valleywise is 2 weeks. And not only is that the average, that's actually what happened in this case in 2022.
And then what happened after he was released? Was he from Valleywise? Was he taken into custody?
That's right. The state received notice that he was going to be, that Valleywise had determined he was stable, and he was being released with an order that he be medicated. And at that point, the state said, well, we believe if you have physicians saying he's stable, and if you have physicians saying he's stable enough to release to the street, and he has to take medication when he gets out, the state felt that those were facts that were sufficient to support a reasonable belief, not that he was newly competent, but that perhaps further restoration efforts would be worthwhile, because you understand that at that point, he had only been in about 6 months of restoration. So there was quite a bit of time left on the restoration. Now, that decision by the state has since been called into question, certainly, and this court knows there's a forthcoming opinion coming from another panel of this court that says, hey, you didn't, the trial court got it wrong on the Johnson factors. We haven't seen that opinion, so we're limited.
Let's talk about hypothetically, that's what this opinion says, and Judge Gentry, in her order, said specifically what in the 2022 case?
So it was this is where the history gets a bit tortured, because the state refiled, and then the Johnson case came out that said, hey, state, you don't get to make this decision by yourself. You need judicial approval on that reasonable belief piece.
That's in the 2022 case.
Yes, and so 2 things happened. Defense Carson filed a motion to dismiss, citing Johnson in the 2022 case.
Right.
The state simultaneously sought retroactive permission from Judge Gentry, saying, hey, we see that now Johnson says we need permission. Can we get permission? And here are the facts that we relied on in making our decision. Judge Gentry, she granted both requests, actually. She granted the motion to dismiss, the defendant's motion to dismiss, but she, through email, this is where we don't have a great record, through email, she granted the state permission to refile.
Okay, so best case scenario, that emailed permission is a court order that says, yes, please refile. You've got the 2023 case. You have another opinion coming out from this court where you just said what's going to happen when that opinion comes out?
So we have a decision order that essentially from that panel says that the 2023 case, the permission to refile is vacated. So in effect, that's a dismissal of the 2023 case.
So why wouldn't that moot the issue before us today?
So if I'm understanding correctly, you're getting at the active case question.
Correct.
Whether we need an active case.
So let me see if I can get you to answer this question before we get into this discussion. If we believe that you need an active criminal case to engage in getting the dangerous trial under subsection 4, then this case would be moot based on the opinion that's going to come out. If, as the state argues, you don't need an active criminal case, then this case would still be active and live and we'd need to address it. Is that what I'm understanding?
Not quite, actually. I would suggest that the ultimate decision that this court will make, and I admit that there's room for argument here on the active case requirement, but what I would suggest to the court is that even if this court decides you need an active case in order to initiate a dangerous trial, that we have that by the grace of Judge Howe's order, decision order, which stayed the dismissal for purposes of the state being able to file this petition. I think the court has the authority to do that.
But how would that work procedurally? So if Judge Howe said, hypothetically, since we don't know what that panel is going to say, but let's say hypothetically he says, we didn't do it correctly, the granting of permission to refile was incorrect, wouldn't that negate the ability for the 2023 case to still be live and applicable? Entirely? I mean, you filed that in the 2023 case, but if you didn't have permission or adequate permission or the permission was incorrect, how is the 2023 case still even viable?
I guess what I would say to that, Judge, is that because we haven't seen the opinion yet, I can't say for sure that the state will be petitioning for review. Yes, but I anticipate that we will be reviewing that opinion for possible petition to review and a stay with the Arizona Supreme Court. So what I would say is that decision that's forthcoming, yes, it intends to eliminate the 2023 case, but I think that decision is not final. And for that reason, and the fact that the state did file its petition while that case is still active, I admit on its last legs, it appears at the moment, I think that we filed it within an active case.
Counsel, can I ask you just a couple of clarification points?
Yes.
With respect to the decision order you mentioned, and I have April 22nd of this year, it might be off by a little bit, but that was in the a special action arising out of the 2022 case, right?
Yes.
Okay, I thought I heard you say 23, and I got a little worried.
Sorry.
So, no, you probably got it right, I probably got it wrong, but I wanted to make sure of that. But, and I don't have that specific order with me, but I don't know that order, which is an order, intermediate order for sure, which did allow the state to file something under 4517, I don't know that I read that as saying that 4517 could be righteous, that for sure 4517 applied sort of as a matter of the law of the case. But I want to make sure I understand you correctly. I thought it was a sort of a procedural opportunity, go see what can work, and then let the kind of dust settle when it settles.
I absolutely agree. Okay. You're right, Judge, that decision order which said, hey, this is what's coming, and we're going to give you 2 weeks to sort your options. Certainly, I'm not interpreting that as, hey, that panel took a look at 4517 and made all the decisions that are now in front of this court. The active case requirement, various constitutional challenges that have been raised, absolutely not. It just gave us that window, and we took it. And I guess it's at this point it's kind of important for me to say, that this is a very serious case. Mr. Carson did walk into a Circle K and shoot a 24-year-old father of 2 in the back of the head for no reason. And he then, attempted to murder multiple other people in the Circle K. All indication we have is that he's very ill. The state believes he's dangerous, and it appears, at least right now, that his threat likely can't be contained through criminal prosecution. Again, we may challenge that decision when we see it, but that's what it looks like right now. And so I think it's important to keep in mind that the state is doing everything it can here and has at every step to try to protect the public, but also to provide treatment to Mr. Carson, which is part of our effort to protect the public.
And before subsection 4 was adopted, Title 36 was your remedy with a guardian or guardian basically appointed.
Yes.
How is that inadequate?
Yeah, so I started to touch on this, but we can look at just at this case, actually, for why the state believes it's inadequate. There was a fair bit of testimony at the legislature, and I don't think that's fully before this court in terms of really a decade or more of situations like this, where offenders like Mr. Carson would, I call it a detour, a stabilization detour. They go over to Valleywise for what's called a petition for court-ordered evaluation. Those that it's determined that warrant treatment are then given an order for treatment, and the average length of stay is 2 weeks before they are released to the street. In this case, there's a new treatment order, which I believe my friend at the bar filed with this court yesterday, that shows that the new treatment order is 25 days. That's what we're looking at, and we consider that to be inadequate, given...
But are you saying that the Title 36 process is flawed?
Yes. Well, not necessarily flawed. Let me say this. the legislature determined that we needed an enhanced process for this very small subset of offenders who are not competent, not restorable, and dangerous. And the reason for that is because the Title 36 process, the framework for it is they don't look past, it's about a 90-day look back. And I don't practice in mental health court, so I do want to be forthright about that. I'm not a civil practitioner, but I have looked into this for this case, and in that courtroom, in front of that commissioner, the evidence that is established through expert testimony of physicians is about a 90-day look back in terms of any conduct that might be considered dangerous. And so what happened, the murder of Efren Hernandez, it doesn't come into play at all when they're determining whether it's a 2-week stay or 25 days of treatment. So I would say, yes, it's inadequate for this type of offender.
Isn't the goal of Title 36 to stabilize the patient and release them back into the community with supervision, including medication requirements? I mean, it's wholly different. Not competent, not restorable. That look is much different than are you safe to live with supervision and under a court-ordered treatment. Do you see what I'm saying?
I do. And maybe, you know, maybe we can speculate here that the legislature in its wisdom should have put this provision over in Title 36 and said, hey, this is how we approach not competent, not restorable offenders, and P.S., here's how we approach if they're dangerous. That didn't happen. It wasn't placed in the Title 36 process. And so what we're left with is the legislature determining we need something else for this type of offender because what's happening in mental health court under Title 36, Chapter 5 really isn't adequate. And that's the legislature's prerogative to make that determination, and they did. And so we have the statute. I also wanted to address a point that was raised in Mr. Carson's briefing that, hey, there's no facility. If this court does allow for the dangerous trial, and if he's found to be dangerous, what next? Because the funding that was attached to that statute and the contracts that were attached to that statute to build the facilities to house this type of offender fell through. And I acknowledge that. That is a sort of a weakness here. But what I would say is the statutory framework is still in place.
So if we go down this road, you're saying then there's no place, and a judge or a jury finds him dangerous, there's no place to comply with the statute at this point in time?
As far as we know. And so what may happen is the state may have to litigate his placement. We may have to, there may be an mandamus action, or we may have to try to compel ASH to take him. I don't have the answer to that. What I can tell this court is that, as far as I know, in the state of Arizona, there has been one defendant who has been processed under 4517A4. This was out of Mojave County, and was found dangerous. And there is a commitment order, and that case is here on direct appeal. That's new. That's within the last couple of days. It's also at the Arizona Supreme Court on a petition for review on several of the constitutional issues that were raised here in this case. So Judge Brown, to answer your question, that is being litigated already in a case that predates Carson. They beat us to the punch by a few months. But I would submit that that's really the executive branch's job to fulfill the statute and to find a place that will take someone like Mr. Carson. Because the point is treatment. It's not to keep him in jail indefinitely. And I admit that that would raise ex post facto concerns.
Understood. Thank you.
Yes.
Where is Mr. Carson today?
I believe Mr. Carson is, despite the treatment order, I believe he's still in jail under the criminal case because it has not been dismissed. Judge Lemaire did have a status conference set this week, I think, to start to sort what's going to happen. And Mr. Carson moved to continue that because of proceedings in this court. I would like to reserve a couple minutes for rebuttal, but I'm happy to answer more questions if you have any that are immediately pressing.
Let me look to my panel mates, see if they have any questions at this point. I'm inclined to give both sides another 5 minutes without objection. So we'll add 5 to yours if you want for rebuttal, and we'll give 5 to respondent as well. We are, and yeah, good, the clock should stop. We have a less robust record than we might otherwise, and that means oral argument is particularly important. It's always important, but particularly important here. So, thank you.
If I could
Oh,
ask
sure.
one more question
Yeah.
before
Yes.
you sit down, since you've got more time. Was A4 on the state's radar before you received Judge Howe's order?
It was. In fact, the legislative side of my office was part of all the county attorneys throughout the state in terms of lobbying for that provision. As far as I know, this is the first, Mr. Carson is the first defendant that my office in Maricopa County has attempted to utilize the statute.
But nothing would have prevented you from bringing that sooner?
In terms
I
of
mean, seeking that option?
seeking the A4 option.
Yes.
Well, we couldn't do it when we first had the finding of not competent, not restorable in 2022, because of course the statute wasn't in effect until
Well,
January.
yeah, I
But
understand.
you're saying
January
between
1st,
January
after
when
the
we
first
filed it in
case.
April, that's
Yes.
about a 4-month window. And I don't know if the assigned trial attorney was considering that
What if
option.
it's legally available? It certainly was legally available.
Yes,
Correct.
we filed about 4 months after it became legally available.
All right, thank you.
Thank you.
Thank you. We look to counsel for respondent. Who are we going to hear from today?
Good afternoon, judges. My name is Kush Gabani. I'm joined by John Champagne. We're with the Maricopa County Office of the Legal Defender, and we represent Mr. Joel Carson. So Mr. Carson was found not competent, not restorable in June 2022. And ever since then, he's been held almost exclusively in solitary confinement at 4th Avenue Jail. And now, despite no valid active criminal charges pending against him, the state continues to hold a profoundly mentally ill person in jail. And they seek to do so through a dangerousness trial, knowing full well at the end of this process there's no facility in the state to treat Mr. Carson. So what this process will amount to is just more confinement in jail for a mentally ill person. And I want to start by talking about the realities of this because of what the state mentioned.
Can I stop you right there? Just
Absolutely.
if you can clarify, where was your client between 2018, when the charges, and 2022?
Where was he?
Yeah, was he in
He was
custody?
in custody in solitary confinement, yes, Judge.
Thank you.
And there was a 7-day period between the 2022 and the 2023 case. Was he released during that 7 days?
No, he was not.
So just to be clear, he's been in custody continuously since on or around late May of 2018 to the present.
So, yes, Judge, there have been pauses to go to Valleywise for evaluation because those mental health orders require a period of evaluation at a behavioral health center. So we went to Valleywise for that for 2 weeks after the initial not competent, not restorable finding in 2022. And then I believe there was another period in that time. But besides those 4 weeks, he's been in jail, yes.
So, and the only time he's been released was to go to a mental health facility for treatment or evaluation. He wasn't just released out into the community.
That's correct.
Okay.
So to address the realities of this, and the state mentioned the case out of Mojave County. And so just to be clear, that defendant, and that's CR, I have the case number as well if the court, like it's CR 2021-0621, I believe. So that defendant was found not competent, not restorable. That was a first-degree murder charge as well. And during the pendency of the 120 days before the dangerousness trial, he was held in custody. He was held in jail. And because there's no facility, he continues to be held in jail. So I'd like to also address the facts of the case as well. So the state addressed the facts of this case. I would remind the court that, again, because he was found not competent, not restorable, there's been no conviction in this case. So also, the state has stated in its briefing that the state has done everything to protect the public. So as we mentioned in our briefing and provided to this court, there is an active court order now for treatment. That's for 180 days from May 10th of last month. Now, that can be extended indefinitely according to statutes, and we cited those statutes in the briefing. And if for whatever reason a peace officer has a statutory authority to make sure that he attends that treatment, there is that statute as well. I believe it's Title 36, 544A. So there is enforcement here to ensure that he receives that treatment. Mr. Carson is not the first defendant to be not competent, not restored when we charge with a serious offense. So I would also say, the state mentioned that the active stay from CR 2022 keeps this CR 2023 case afloat. I don't believe the court can use the CR 2023 case for another, or 2022 stay rather, for another 4 months to allow for this dangerousness trial. While we don't have the opinion, we know that there was insufficient evidence of regained competency. Now, it's based on a due process violation. So what this court said is that the state violated Mr. Carson's due process rights by refiling charges in CR 2023. It doesn't make sense that they would then get a windfall to be able to pursue a dangerousness trial in CR 2023 through that stay.
So once the stay is lifted, what is the effect of that decision on what is before us?
As this court stated, I believe CR 2023 would be dismissed because there is no active case. This court stated in Johnson v. Hartzell there needs to be evidence of regained competency because there is none. That case must be dismissed according to that case, Johnson v. Hartzell.
And if the case is dismissed, that leads us to the, do you need an active case to engage in a dangerousness trial? And if so, what's your best argument to support that?
Absolutely, Judge. So the text of the statute states that that's Title 13, 4517A4. That states that the defendant is charged. But if the defendant is charged with a serious offense, that's not was charged, at one point was charged, it's is charged. It's a present offense, indicates that that is an active case. In addition, 13, 4517, and 4521 both refer to the person as not a petitioned person. They're a defendant, meaning there are active criminal charges here. In addition, the charges are only dismissed after a finding of dangerousness. And that's in the statute as well. That's 13, 4521F. So clearly the legislature contemplated that active charges would be required for this dangerousness trial, and the state even agreed with us in its initial round of briefing that an active case is required.
What are we to make of that? Is that binding, or is that?
Well, Judge,
because we've heard, I think, from both sides that at some point the other side said something that is either dispositive or undercuts, their positions now, and those are legal arguments, not, I don't think, factual representations. When you get to facts, you can't blow hot and cold with the truth, but litigation and advocacy can and should change over time, and so that's why I ask.
I don't believe that statements from the other party are necessarily binding all the time. But what I will say is that it's concerning that in the CR 2022 case, in that special action that's still ongoing, the state has said that an active case is required. And that was the sole basis to extend the stay in that matter indefinitely. And they made that argument several times. So we've moved to vacate the stay in that case because it seems like the state has withdrawn its sole basis for that. And so that's a question for a different panel. But our position has stayed consistent that an active case is required for the filing of these charges.
But just to follow up on that, so if the opinion in the other panel comes out and explains its reasoning, and the day that they issue their opinion, if the stay is lifted, then is it your opinion then this special action becomes moot?
Yes, Judge.
There's nothing for us to decide.
There's no dangerousness trial, so it would be moot. That's correct. Judge Lemaire's decision can be affirmed for any reason. It would be affirmed for that reason. It would come moot.
Can you talk a little bit about, you made some arguments about the indefinite incompetency treatment process. I'd like to hear a little bit more about your take on that.
Sure. So before January 1, 2024, before January 1 of this year, so the way this worked is that a person would be evaluated by two doctors. Those doctors find the person not competent, and then most of the time doctors would say, okay, not competent, but he's restorable. And there's some degree of restoration treatment. So then there's a maximum of 21 months of treatment, and at the end of that process, in this case, Mr. Carson was found not competent, not restorable in that time. So at that point, after that finding, after that hearing, that court hearing and a finding of not competent, not restorable, there's no more restoration treatment. It's over. And that was stated by this court, Noel versus Reese, consistent with due process and the state statutes. But now, which is extremely concerning, is that not competent, not restorable defendants, the court now still has the three options that it originally had before January 1, but now has a fourth option about the dangerousness trial. And dangerous individuals, if they're ultimately found to be dangerous, they're the only subclass that continues to receive competency treatment. That's in the statute, in the 4521F. The defendant shall receive education, care, supervision, and treatment to render the defendant either competent or non-dangerous. So in Mr. Carson's case, this commitment could potentially be indefinite. So this would be indefinite competency treatment that continues. And to be clear, the commitment is based partially on his lack of competency in 134521G2A.
Doesn't H provide a limit to the length that treatment and education can go on?
It's defined by the presumptive sentence. In most cases, yes, there is a limit there, but because Mr. Carson's presumptive sentence is life.
So this is a specific to Mr. Carson's case that it is an indefinite period of time that he'd be required to engage in treatment.
That is correct.
Counsel, let me just clarify your reference to F and competency. That's one of the two grounds, right? But the other is non-dangerousness, correct?
That's correct.
So it could be a mere continuation of Rule 11 competency services, or it could be something completely different, or it could be both. Is that fair?
Well, given, and we've cited this in our briefing as well, that in Title 36 there is statements about what treatment the defendant would continue to receive, and that is competency treatment, additional competency treatment. So, and that's in Title 36.
No, and you're right. I'm just looking at the last sentence of F. The defendant shall receive education, care, supervision, and treatment to render the defendant either competent or non-dangerous. And that's what I was focusing on.
So, I mean, my understanding is that the treatment would be both, that it would be competency treatment and dangerousness treatment, and that if the person is competent, they'll most likely refile charges, or if they're non-dangerous, then a different outcome would be there. But I believe both avenues would be sought because both there are grounds for commitment on both sides.
This being a novel kind of argument, because we don't know how this works in dollars to donuts on the street. But so if they restored him to competency after the 21-month period, could they refile the charges? That's just off the top of my head, kind of a strange argument because they were limited and now they've got this additional thing. Kind of interesting. Probably not relevant to what we're discussing now. Sorry about that, but.
No, I mean, to answer the court's question, this was contemplated, in Ryder in 2013, this court's case in Ryder, in which, civil commitment that treatment can bring about competency, and that's evidence that can be used to show, hey, he's competent now. So, there is additional, that court just considered that civil commitment can be evidence of competency in terms of the treatment that they receive in those proceedings.
I wanted to come back to just clarify, Judge Campbell had asked you about mootness, and I thought I heard you say that this court can affirm on any ground, which is true in the appropriate circumstance, but mootness is not affirming. Mootness is simply dismissing the either special action or appeal. Would you agree?
Yes, Judge, that
Okay.
mootness is different, but
Okay.
it would, yes.
And just to follow up on that, there are times when, and actually in Title 36 cases, it's because of the tight window, some of our opinions, we actually recognize that the commitment order is moot, but we go ahead and issue the opinion anyway to provide guidance, an issue likely to recur, an issue of broad public importance. Are either of those issues present here such that we would want to, I don't want to invite myself to do more work here, but if it's necessary, I'm just wondering what your thoughts are on, does this involve an issue of broad public importance or issues likely to recur?
Absolutely, Judge. I agree that at this point we all need clarification. We all need clarification. This is Mr. Carson's fifth, I'm losing count now, fourth special action in a year, and to address these the questions that this court raised and to us in supplemental briefing, I think it would go a long way in providing that guidance. Because I think that I don't think there are factual disputes when it comes to there's no facility after the proceeding right now to do this, and that another 120 days in jail pending a dangerousness finding it violates due process. I think this has happened, like we said, in Mojave County, and if we just kick this down the road, then we'll be back here. 2 weeks, 3 weeks, another special action in front of a different panel, raising the same procedural history. I filed the same appendices like 6 times now, so I don't know that I don't know if it. I think that like the court alluded to, I think that the bar needs clarification here. Yes. And to add a little bit more about that the defendants cannot be held in custody pending the 120 days of the dangerousness trial. It does, when you compare it to the SVP statutes, the state compared these statutes somewhat to the SVP statutes, sexually violent persons statutes in Title 36. A key difference is in that area of the law, a person is petitioned to be SVP. There's a probable cause determination, and immediately that person is taken to a licensed facility under the supervision of the Arizona State Hospital. That's in the statute. That's in Title 36. Whereas here, we've already court has already filled in the gap that he stays in jail for another 120 days. It just violates due process to do that. Title 36 and the SVP statutes have been found to be regulatory in Martin versus Reinstein, but this statute is very different, seemingly in where the person is held pending these various timelines.
Counsel, that issue, though, really isn't before us now because there's been no finding under, A4 or otherwise that would implicate the 120 days, right? That could be a domino that would fall later, but as the case comes to us right now, we have an order in the 2023 case that we're asked to address that said no.
That's correct, Judge. But as I stated, I think the defense bar needs clarity as to what this is. This court asked us a question as to whether these statutes can be applied retroactively. A key component is whether the statutes affect the defendant's substantial rights, and if they increase his punishment in any way. So this concept of punishment is clearly briefed. I mean, I think that the court has that briefing and can address that question for additional clarity here for the bar.
And I understand your position. In preparing for today, it strikes me that if this case was 2 years older, let's say the alleged criminal acts occurred the first part of this year. Let me rephrase it. The feathering in, the retroactivity, the issues we're asked to grapple with wouldn't exist. And if we were here 2 years ago, before A4 became effective, we wouldn't exist either. This dispute wouldn't exist. So it strikes me that we're kind of in this middle ground that makes things so challenging.
That's correct, Judge. And I would note another things before my time is up about the ex post facto arguments that we raised in our briefing as well. I think that it's concerning that, as the states informed this court that it knew about the A4 provision before the decision in this court, before the decision to CR 2022 special action. I mean, that tells me that, if you can't punish him through CR 2022, then we'll do whatever we can to do that. So I think it's an initial indication this is a punitive action by the state. In addition, I would add as well that, in Kansas versus Hendricks from the U.S. Supreme Court, there's a consideration of the punitive versus regulatory nature of statutes. And a consideration there is whether the state has to prove evidence of criminal mens rea to commit someone. And that the proof of criminal mens rea shows that it's a criminal statute and not a civil regulatory statute. And to commit a defendant or a dangerousness trial, there has to be a proof evident, presumption great showing of all the elements of the offense, including a criminal mens rea. So to get a commitment, there needs to be proof of criminal mens rea, and that would add to the punitive nature of these statutes. I would also add that the state indicated that it was an intentional act from the legislature to not include these dangerousness statutes in Title 36, and that that's in Title 13 for a reason, indicating that it is additional grounds for punishment. Now, given all that I've said, does the court have any additional questions as to the briefing?
I just want to clarify real quick. When you're talking about is it procedural, is it substantive, you said that the 120 days has to be served in custody, and that depends on whether the defendant is in or out of custody. But you think that is punitive in nature, that 120 days? Was
Yes.
that your argument? I just want to make sure I understood clearly.
That's correct, Judge. That the 120 days would be punitive because, defendants are charged all the time, right? They're charged with crimes. They are detained in jail, and they're awaiting a prison sentence. They're awaiting a jail sentence. But Mr. Carson is not awaiting a jail or a prison sentence. He's awaiting a treatment at a behavioral health facility. The purpose at this point, as the state mentioned, is to treat Mr. Carson. So it doesn't make sense to hold him pending treatment, hold him in solitary confinement in 4th Avenue pending treatment at a behavioral health facility.
And so the reasoning in the Reinstein case regarding sexually violent persons is not applicable in this circumstance, in your opinion?
Again, because it's different, because there's a probable cause hearing, and I'm equating that to a proof evident presumption great hearing in dangerousness statutes, but there's a probable cause determination, and immediately that person is taken to a facility for treatment. Whereas in our case, the person is held in jail for another 120 days. And the state is moving to affirm his release conditions. It doesn't seem like there's been any change in that position in the briefing for this court. And as we've seen in Mojave County, that was the practice, is to hold the person in custody for another 120 days. I don't think that, I believe that violates due process.
So that seems like you're saying the statute as written is unconstitutional in that regard.
That's correct, Judge. Well, what I would say is that there is no mention of where the person is held. There is no mention in the statute of where the person is detained pending the 120 days. We just don't know. And the court action of detaining someone or holding them in jail for another 120 days would be unconstitutional.
Thank you, counsel.
Thank you.
Appreciate it. Ms. Davis, rebuttal.
Thank you. I would like to just touch on that last issue about the 120 days. I don't think the ex post facto issue is properly before this court. I don't think we have an adequate record. I think if this court is interested in that issue through the supplemental briefing, that it really would have to be remanded to the trial court to address the Martinez-Mendoza factors. And as I mentioned before, that constitutional challenge, among others, is already pending at the Arizona Supreme Court. So, it could be duplicative work. I mean, we have different cases for sure, but I did want to point out those issues are in front of the Supreme Court, and I just don't think you have the record here on ex post facto. But to be clear on 4517A4, it doesn't say the defendant has to be held in custody for 120 days. There's no per se requirement. It says he gets a trial within 120 days. So presumably, although it doesn't specify, but presumably a defendant would be able to ask for release conditions. Now, realistically, is Carson going to be released pending that dangerous trial? Not likely, and it's not something the state would agree to. But I just want to point out that on its face, the statute doesn't require an additional 100 days of custody. Moreover, the law is pretty clear that pretrial release conditions aren't considered punitive in an ex post facto analysis, and that's Simpson v. Owens.
But when you talk about pretrial release conditions, there will never be a trial in this circumstance, other than the dangerous trial, and I don't think that's the trial they're referring to in that.
Well, I mean, the dangerous trial is set up as a jury trial. The rules of civil procedure apply to the trial.
It's not a criminal trial.
It's not a criminal trial.
Release conditions are completely tied to the criminal trial and the charges.
True, although this would be sort of a quasi-trial where an individual who is charged with a serious offense, alleged to be dangerous, and has been found not competent, not restorable, is subject under 4517 to the ongoing release conditions of the criminal case.
Of course, what you're saying is that there needs to be an active criminal case.
I don't think so. I think there needs to be I think that, I got to be careful here with how I answer your question. If there needs to be an active criminal case, it's to initiate the trial. There's nothing in the statute that it says any party may request any of the following four options. And one of those options is the dangerous trial. And so I would suggest to the court that if this court finds an active case requirement, that we met that. We got the petition in. Now, there's a point.
Let's just run that to ground real quick. So there's a case, you request it, the case is dismissed, you're still awaiting a trial. What authority do you have to impose release conditions on a defendant who's not a defendant anymore but is just awaiting a dangerous trial? Where do you get the authority to impose release conditions?
I understand. What I would say is that I read 4517 as creating an ancillary proceeding. And what I would give the court as examples is there are plenty of criminal cases where the charges are dismissed for a variety of reasons, or someone's acquitted, or and the shell of the case remains, and the law provides for processes down the road, for instance, expungement. No one says when a defendant files a petition for expungement, well, sorry, that's not an active case anymore because the charges were dismissed, or the court lacks jurisdiction because it's not an active case.
But expungement and most of what you're discussing has nothing to do with the liberty of an individual, which is a pretty paramount constitutional right. Would you agree with me?
I do agree with you on that,
Okay. Do you have
Judge.
anything that would be a corollary?
Well, you're right about, I mean, so I guess I'm saying there are instances where the fact that the criminal charges have been dismissed, that doesn't inactivate that case so that the judiciary can't touch it again. Another one would be restitution. There are situations where after a case has, a defendant's been discharged from probation, the criminal charges aren't active any longer, an outstanding restitution debt there can be an ancillary proceeding to turn that into a criminal restitution order. I admit those aren't as strong because of the liberty interest, as the court points out, but I guess what I would say is I think when you get that petition filed, you have started the process of an ancillary proceeding that can exist under the criminal shell. Now, once there's an administrative order that I provided to this court, so the Arizona Supreme Court has already looked at some of how these processes would play out. And once a dangerous trial is ordered and a finding is made, the Arizona Supreme Court says at that point, you open a separate Title 35 case, and the 4517 proceedings and the 4521 protections and safeguards, for instance, twice annual review, possible release to a less restrictive facility, all of those hearings take place in the ancillary case. To answer your question earlier, yes, if a defendant is discovered to be competent, the statute says that the state could refile charges, but it also provides that any time spent committed pursuant to a dangerous finding is credited against any ultimate sentence. Just sort of in closing, I am out of time, but I guess again I just want to say that I agree actually with my friend at the bar that both sides could use some guidance from the court, and that's a big burden to put on you because this is difficult. But we're asking for guidance that, pursuant to Johnson v. Hartzell, a finding of incompetence and not restorability attaches to Mr. Carson and to the charge. I think that's pretty clear. I don't think that piece will be terribly difficult for the court to resolve, and I think an instruction back to the trial court that, hey, you may deny their petition on other grounds, but this particular ground that you chose isn't valid. So that's our request.
Counsel, we appreciate your briefing. We appreciate your presentation today. You have given us much to think about. You've filled in some gaps that were important to us. We'll take the matter under advisement and we'll issue a written ruling in due course. Court's adjourned.